Well, welcome everyone to Washington Legal Foundation's media briefing on the U.S. Supreme Court term. My name is Glenn Lambie. I am Executive Director and Vice President for Legal Studies of the Foundation. Those of you not familiar with the Foundation, this is our 46th year of free enterprise advocacy and education. We endeavor to do that through amicus briefs in the state and federal courts at all levels. We also do extensive publishing and blogging, as well as programs such as this one. If you'd like to learn more about our work in these areas, you're welcome to check out our website, WLF.org, once the program is finished up. So this term, the court issues 57 opinions, 29 of them coming out in June alone. That's 51% of all cases decided in just 1 month. Now that everyone's had a chance to catch their collective breath after that sprint to the finish line, we're pleased to present our 35th annual review of the term. In terms of what WLF did this term, we filed 24 amicus briefs at the cert stage and on the merit stage this term. The party the WLF supported prevailed in 8 out of the 11 argued cases that we filed on the merits, and we successfully supported 3 cert grants as well. Our panelists will discuss some of those cases today. I want to remind everyone that we're recording this, and if you have any questions, please use the Q&A widget that Zoom provides, and then we'll direct the questions to our presenters. First, introduce Sarah Harris, who's a partner to Williams & Connolly in Washington, D.C. She's represented clients in high-stakes appeals in the U.S. Supreme Court and federal and state appellate courts across the country. She clerked for Justice Clarence Thomas, First Circuit Judge Sandra Lynch, and D.C. Circuit Judge Lawrence Silberman. We're especially proud that Sarah is a member of our Legal Policy Advisory. Also joining us today is Julia Malkina, who is a partner with Sullivan and Cromwell in the New York office. She's a member of the litigation group and co-lead of the firm's securities litigation practice. Julia joined the firm in 2015 after serving as a law clerk to Justices Sandra Day O'Connor and Stephen Breyer. Was also a Bristow Fellow in the Office of the Solicitor General and a law clerk to then D.C. Circuit Judge Brett Kavanaugh. Also joining us today is Adam Unikowksy, who's a partner with Jenner & Block in the D.C. office. He has extensive appellate experience, including 9 Supreme Court arguments. He clerked for Justice Antonin Scalia and D.C. Circuit Judge Douglas Ginsburg. He also offers very thorough analysis on the law and legal developments on his Substack site, Adam's Legal Newsletter. I definitely recommend to everyone who's joining us today. So we'll have each panelist in the order that I introduced them, Sarah, then Julia, and do opening statements. Sarah?
Thanks so much to WLF for having me. I would say this is an exciting term, but the theme that I want to start off with is it could have been an even more exciting term because a lot of the blockbusters sort of fizzled. The mantra coming in, if you read any press coverage of the term, was this would be like the biggest term ever. The Supreme Court would sort of upend all sorts of areas of law potentially. And there were really 3 big blockbusters that stayed big. The Harvard case, which ruled out affirmative action in university admissions, the student loans case, in which the court held that the president's student loan forgiveness program lacks statutory authorization, and then 303 Creative, in which the court held that you cannot compel an individual engage in creative services, creative expression, to violate his or her conscience, even under public accommodation laws. So those were the classic sort of cases that I think people expected coming into the term would be 6-3 decisions. They were 6-3 decisions. We can talk more about the reasoning of the cases and what that sort of tells us about the court, but they stayed big. And the big storyline, I think, of the term is what didn't get big and what kind of fizzled. And those 3 cases are Moore versus Harper, Halen versus Burkeen, and Milligan. So 3 cases where the conventional wisdom was these would also be 6-3 cases, perhaps adopting the independent state legislature theory, under which state legislatures alone would control redistricting. The court was, considering the constitutionality of the Indian Child Welfare Act, and the court was considering also Alabama's maps, which a 3-judge court has struck down. And all of those cases defied the predictions in the press. In all of them, the chief in Moore wrote for 6 justices to say the independent state legislature theory is not a thing. In Burkeen, Justice Barrett wrote for 7 justices rejecting many constitutional challenges to the Indian Child Welfare Act and essentially punting others on standing grounds. And in Milligan, that was probably the biggest surprise of the term, just because the Supreme Court had, in a 5-4 decision, issued a stay of the decision that overturned Alabama's maps. So you would have perhaps expected maybe that vote would stay stable. And if you thought that, you'd be wrong, because Justice Kavanaugh joined the chief and the 3 liberal justices on the merits in saying that the maps were invalid. So what kind of explains this trend line? I mean, that's a question on, I think, everyone's mind. Why did all of these big cases get granted only to sort of fizzle out or end up in a place that people didn't expect them to go? Reasonable minds, I think, can disagree about how the court interpreted its precedents, but on a lot of the cases, the court really seemed to have a running, really conscious, in the opinions, effort to say that it was not going to overturn precedents this term. You might have noticed this if you read the Harvard opinion, for instance, where the court, the chief's opinion, it talks at great length, and Justice Kavanaugh's concurrence are also sort of about not overturning Grutter, interpreting Grutter. But this is a trend line through a lot of the other cases as well. If the court or the majority sort of felt like a different result would require overturning precedent, this term they said not so fast. And so it's a sort of very different message, perhaps, than people, especially advocates, took from last term, where perhaps the message was more a swing for the fences. The court might have more of an appetite to overturn precedent or at least revisit it. This term, the message is the way to win is to give the court a path from existing precedent to the judgment line. Another way of looking at the term is just thinking about who won and who lost. The biggest winner is probably the chief. It was his court. He wrote most of the big opinions, and he was the justice most in the majority across the board. He also brought Justice Kavanaugh along with him in some of the big opinions, like Milligan that I just talked about. And he also forcefully hit back against critics of the court in what was essentially the last thing he said to people of the term, his opinion in Biden versus Nebraska, the student loan case, where he criticized the notion, that he said it's a disturbing feature of some recent opinions to criticize the decisions with which they disagree as going beyond the proper role of the judiciary. And the chief, for 6 justices said, don't mislead the public. This misperception will be harmful to the institution and the country. So the chief's court and the chief, I think, in that opinion, is hitting back not only at the dissenters, but at a lot of, I think, the narrative of the court. The biggest losers, by contrast, were, if you look at just on who was in dissent the most, Justices Thomas and Alito, which going into the term, I don't think people would have predicted. They dissented 13 times in respective cases, and contrast that with 8 times for Justices Sotomayor and Jackson. I don't think anyone would have guessed that at the start of this term. The other biggest losers are probably, I would say, elites. I mean, Harvard, highbrow art in the form of Andy Warhol, administrative mandarins, and big business all suffered a lot of, sadly, painful losses if you are fans of big business or other people on that list. And some of the tenor of the opinions was very much sort of, we do not trust elites. Think about the chief's affirmative action opinion deriding the university's trust us approach, or Justice Sotomayor taking the Andy Warhol Foundation to task for the idea that Andy Warhol or other artists who are creative geniuses should get special license when it comes to copyright law. And I think, again, it's worth emphasizing this point because it just is so starkly different from what you might think from reading some of the press narratives about the court and the feeling in the press that perhaps the court is a province of, the pro-billionaire contingent. Billionaires did not fare great this term, especially big businesses. And we'll talk about some of the cases once we get into the case-by-case discussion, but really not a great business term, a fair number of losses that hurt there too. So with that, I will open the floor, but fascinating term.
Thank you, Sarah. Julia?
Thanks very much for inviting me to speak today, Glenn. I thought I would start with an area of the Supreme Court's jurisprudence that I know is important to WLF, the court's administrative law docket, with a particular focus on structural constitutional challenges. So what do I mean by that? Over the last decade or so, but intensifying in the last 5 years, the court has scrutinized whether some of the basic design features of administrative agencies can be squared with separation of powers principles. For example, a number of cases have found constitutional defects under the Appointments Clause or with respect to the president's removal power. In the case called Free Enterprise, the court held that principal and inferior officers cannot be protected by 2 layers of for-cause removal. In SALA law, the court held that Congress cannot create an agency that both has a single officer in charge and also provides that officer with for-cause removal protection. And in Lucia, the court held that SEC administrative law judges, or ALJs, are inferior officers who cannot be appointed who must be appointed consistent with the Appointments Clause. There are several other cases I'll just mention to give you a sense of how active this area has been in the last couple of years. The court's removal decision Collins, its Appointment Clause decision Orthrax, its 7th Amendment decision in oil states. Now, last term didn't have a decision that advanced the substance of the law in this area, but it did have an important procedural decision. That was the court's decision in Axon, which resolved 2 cases, Axon and Cochran. In Axon and Cochran, the plaintiffs are bringing what I think of as part of the next generation of structural challenges that build on the precedents that we just discussed. In Cochran, the plaintiff is the defendant in an SEC enforcement action. Now, she wants to combine Lucia and free enterprise to argue that SEC ALJs, who are inferior officers, can't constitutionally do anything because they have 2 layers of for-cause removal protection. In Axon, the plaintiff is the defendant in a Federal Trade Commission enforcement action. Axon wants to argue that FTC ALJs also improperly have double for-cause removal protection. Axon is also bringing a separate constitutional challenge to the structure of the agency that combining the functions of prosecutor and judge in one actor, the FTC itself, violates the separation of powers. Now, the Supreme Court granted cert to address a timing and venue question, whether Axon and Cochran could raise their structural constitutional challenges to the agency adjudications against them in a claim for declaratory or injunctive relief in federal court now, or whether they have to wait until the agency proceedings against them are over and then raise those challenges in their appeal to federal court. The court held that both plaintiffs can bring their structural challenges to the agencies in district court now and don't have to wait until the agency proceeding is over. We'll get into more detail on the court's reasoning and the implication of this decision later. But for now, just 2 opening observations. First, the court's resolution was unanimous, although Justice Gorsuch concurred only in the judgment. And second, Justice Kagan's decision for the court relied heavily on the notion that these types of structural constitutional challenges are, quote, extraordinary and go to the very existence of the agency. Legally, that was a good reason to allow plaintiffs to bring these claims immediately rather than channel them through the administrative process. But it's also striking that all of the justices seem to agree that the stakes of these structural constitutional challenges are high. Past decisions like free enterprise or Lucia may have felt a little technical or in the weeds of the administrative state. The stakes weren't necessarily as apparent on the surface of the court's decision. But now everyone agrees what the stakes are, and the stakes are high. Last week, the court granted cert in a structural constitutional case where the stakes are indeed very high. Jarkessi. There, the Fifth Circuit held that SEC administrative proceedings before ALJs suffer from 3 separate constitutional defects. First, SEC proceedings before ALJs for civil monetary penalties violate the 7th Amendment's right to a jury trial. Second, Congress violated the non-delegation doctrine because it did not give the SEC any principle by which to decide whether to bring enforcement actions before ALJs or in federal district court. And third, the Cochran argument. SEC ALJs have impermissible double for-cause removal protection. So next term is already shaping up to be an interesting one for structural constitutional challenges. And with that, I'll reserve the rest of my thoughts for later in our discussion.
Thank you, Julia. Adam, if you could finish up with our opening statements.
Sure. So as my colleagues have already described, this term had a mix of outcomes. You had some cases with the typical 6-3 majority with sharp dissents and sharp majority opinions on sort of party line votes on social issues that are very controversial. And then you had some other results that seemed a little bit weirder, like Brackeen, which is a weird 7-2. You had Allen versus Milligan, which was a weird 5-4. Similarly, cases like Moore. And so at the end of each term, people often ask why. Why is it that some cases the conservative position just seems to win on such typical grounds, and then other cases you get these weird outcomes that it's hard to figure out what the court even held sometimes. I think that the line I draw this term is that the court was willing to extend precedents in areas in which the law was already relatively stable and a decision in a particular direction wouldn't destabilize the law. And in that area, the court was willing to do that. Whereas the court really wasn't willing to dramatically destabilize prior areas of law, even though it may have disagreed with them. So just to look at some of the data points here, 303 Creative was not a case that was dictated by precedent. There's certainly ample precedent to support both sides. You had the CLS versus Martinez case on the other side, on one side, and Boy Scouts versus Dale and Hurley on the others. Essentially, you can weave a holding in between both sets of precedents. And in that case, I think the justices tend to go with their jurisprudential priors, and you got a 6-3 opinion along, typical, I guess, party lines, you might say. Similarly, with the student loans case, you had a new statute. You had typical philosophical questions about the relationship between the executive branch and Congress. You had no real authority on point interpreting this particular statute, and so the justices were sort of free to cast the votes that you'd expect based on their ideological priors. The affirmative action case was a little bit different. The court either maybe overruled, maybe sharply narrowed. It's unclear exactly what happened there, but Grutter really doesn't have that much force anymore. On that issue, though, I think the justices have just such strong views on the issues that they've written about these issues before that I think it would have been hard to get the majority to follow Grutter when they disagree with it so strongly. I think in the other line of cases where the court went in, for lack of a better word, a more liberal direction, it's because they weren't willing to dramatically destabilize the law. I was struck by the Brackeen opinion, where basically the majority opinion says, petitioner has not come up, or the Brackeens have not come up with any coherent theory that would allow us to stick to 200 years of Indian law, or we're not going to just throw that all out the window and start again. And actually, Justice Thomas actually does kind of want to do that. That's what he said in his dissent, but there weren't 5 votes for that in the case. And basically, Justice Barrett said, well, I can't think of a way to not totally destabilize federal Indian law, so we're sticking with it. And that means that ICWA is constitutional. Moore versus Harper, similarly, it was like an extremely broad position that was presented. They were saying that state constitutions could never, under any circumstances, be binding with respect to state statutes enacted by the legislature. That would really have such significant effects, and there's no limiting principle that was really offered, as the court noted in its majority opinion, and the court said we're not going to do that. And I guess Allen versus Milligan is another example of that phenomenon. It was funny, at the stay stage, Justice Kavanaugh voted for a stay, but he wrote a separate opinion saying, well, under the Purcell principle, I'll vote to stay it, but it's a close case, so I'll have to figure this out. And then when it came to the merits, essentially, I don't think Alabama could come up with an argument that wouldn't de facto overrule Jingles and prior Section 2 cases. And so I think Justice Kavanaugh just said no, he wasn't willing to overrule precedent. He maybe wouldn't extend it, but he wouldn't overrule it. In fact, ironically, I think the cases most destabilizing were cases in which the business side lost. The most surprising case of the term this year for me was Mallory. I did not think there was 5 votes for that position. Maybe the effect of Mallory will be blunted by the Dormant Commerce Clause argument that Justice Alito put forward, but that could be a very dramatic case. And then, of course, there's the National Port case, where I still don't exactly understand what the rule of decision is. Maybe there is no rule of decision, but the court came very close to wiping out lots and lots of Dormant Commerce Clause cases. In terms of next term, I'll just make one comment and then I'll be silent. I think there's 5 seminal administrative law cases next term, which seems weird when you look at the list of cases. But I actually think that Jarkissi is 3 of them all in one. I think that each one of those questions presented itself would be a seminal administrative law case. One about non-delegation, one about the 7th Amendment, one about removal. Each one of those cases would be huge. Together, it's probably one of the biggest administrative law cases ever. Of course, it may be rivaled by a case seeking to overrule Chevron and a case seeking to wipe out the CFPB. And so I think that, those will be whereas I think social issues were primarily the story of this term, those cases will be what will be remembered for next term unless some bigger case comes along, which is obviously quite possible. And I'll wrap up there.
Thank you, Adam and all. So let's circle back to the Axon and Cochran opinions with Julia for a minute or so. You elaborate a little bit on what the justice's rationale was in that case, and also does what they did in that case send any signals to those that are going to be involved in the Jarkessi case next time?
Thanks for bringing me back to Axon and Cochran, Glenn. With respect to the reasoning of the court's decision, it's actually fairly straightforward at the end of the day. Federal courts start with jurisdiction to consider claims arising under federal law, including structural constitutional challenges. So the question is whether Congress has withdrawn that jurisdiction by substituting an alternative judicial review framework. Under a line of decisions, beginning with a case called Thunder Basin, the usual rule is that Congress has substituted an alternative judicial review framework for challenges to agency decisions. You see that in most agency statutes. Normally, you have to go before the agency first, then you can seek judicial review once the agency enforcement action is over, usually in the DC Circuit or another federal court of appeals. In Axon, the court ruled that this alternative review scheme, however, doesn't cover every possible argument one could make, and indeed doesn't cover structural constitutional challenges. And that's so for three reasons. First, for structural constitutional challenges, later judicial review won't be meaningful. The plaintiff's argument is that they never should have to go through the unconstitutional agency action in the first place. Second, the legal issues are collateral to the issues the agency will be deciding. For example, whether Cochran violated the SEC's accounting standards. And third, whether the agency is unconstitutionally structured is plainly not a question within an ALJ's or an agency's expertise. Now, with respect to signals for Jarkessi, I think the short answer is no. The result in Axon was 9-0. However the court decides Jarkessi, I doubt it's going to be unanimous. And it would have been very surprising had the court denied cert in Jarkessi, given that the First Circuit held that all SEC administrative proceedings are unconstitutional. So I don't think we can infer anything from the cert grant about the likely outcome on the merits. Now, the longer answers are slightly different for each of the three questions presented. On the Seventh Amendment question, Axon does shed some light on Justice Thomas's views because he wrote separately to suggest that the Seventh Amendment issue is a serious one for the SEC. Now, some might be tempted to speculate why no other justice joined Justice Thomas's Axon concurrence. But I don't think you can really read anything into that, and we'll have to wait until Jarkessi to see where the justices are on the Seventh Amendment issue. On the non-delegation and double for cause removal questions, Axon itself doesn't give much guidance. Many have expected that the double for cause removal question will go against the SEC since the court's decision in Lucia. But footnote 10 of Free Enterprise, the case that established the double for cause removal rule, went out of its way to state that ALJs present a distinct removal question because they perform adjudicative rather than policy-making functions. So I guess now 13 years later, it looks like we'll get an answer to whether that actually makes a difference from a constitutional perspective.
The Axon case somewhat falls into the realm of separation of powers, which is a big area of WLF. That came up somewhat prominently in our brief in the Polanski False Claims Act case. Sarah, can you comment on Justice Kavanaugh's concurring opinion in that case and also Justice Thomas's dissenting opinion as to how those arguments might move arguments on the constitutionality of the keep tam provisions forward?
I would love to, because in case you missed it, this was a scintillating and gripping case of Polanski about the False Claims Act and basically at what point the United States can intervene to dismiss these suits. So look, if you didn't see this one, don't feel bad. There is a really interesting series of opinions nestled in it that Glenn just referred to, where Justice Thomas in dissent and then picked up upon by Justices Kavanaugh and Barrett in a concurrence said, Whoa, wait a minute. The KTM statute is probably unconstitutional. So that's sort of like the sleeper, the big sort of like headline buried in what might otherwise be a sort of sleeper opinion. Justice Thomas is articulating the view that Article 2 prohibits KTM suits because you have a private actor or relator who is essentially seizing away or taking the government's power to pursue civil actions for false claims against the government. And, you know, it's so funny, like what's old is new again. I think that was about the hottest topic when Bill Barr was Attorney General the first time in the early 1990s, like truly like really, really hot in the Department of Justice. And it's coming back again. And so I can't tell you how it's going to get decided by the court, but what I can tell you is having seen the 3 justices express strong interest in this question is sure to guarantee a lot of cert petitions on it. So stay tuned.
Adam, any thoughts on either Axon or Bladsky before we move forward?
Well, I was going to talk about some separation of powers implications of other cases. I'll say one thing. I have my doubts that the court's actually going to wipe out the False Claims Act. That would be pretty incredible. I mean, I think that the first such statute was passed by the first Congress, signed into law by President Washington, I think. I mean, now that's not to say that's dispositive, but, you know, having litigated False Claims Act, you know, cases all my career, I think that my clients would be very happy if it was wiped off the planet, but I guess I'll believe it when I see it. You know, but just I wanted to say one word about separation of powers in another context. I actually view the Mallory case as fundamentally a separation of powers type of case about the proper role of the judiciary relative to Congress. You know, one interpretation of the case was that the court had just had it with judge-made standards in personal jurisdiction. It's actually a very difficult area to know like what targeting is, exactly what contact you have to have with a particular state to get sued. And, you know, I think the Supreme Court's holding places the ball squarely in Congress's court. It's clearly within Congress's Commerce Clause powers to preempt state legislation requiring you to submit to jurisdiction. Also, this Dormant Commerce Clause issue that was raised by Justice Alito can be overturned by Congress. So I think that the Supreme Court just viewed it as the type of problem that Congress is well equipped to deal with, and even in our polarized times can deal with. So that's my interpretation of that decision.
Sarah, one of the doctrines that helps to preserve the limited role of our government for the judiciary is standing to sue, which is sometimes considered to be a sleepy issue of some sorts or a procedural issue by some people, but every plaintiff has to establish in his or her complaint that they're standing. That doctrine played a pretty major role in several cases this term. What do you think of what the justices had to say about standing this term?
So this is another like super important B plot of the term that I think people were not following as much because, let's be honest, like not a lot of people follow like standing super avidly, but you should. And because this was actually a big term on the standing doctrine. So I think the biggest takeaway for me is that for a long time, like since the case called Massachusetts versus EPA, there was a sort of idea that states are special for standing purposes. They get so-called sort of quote unquote special solicitude when it comes to establishing standing. And states ran with that. They became on both, you know, for both red and blue states, super prolific challengers of all kinds of administrative action by the federal government, or in the case of the United States versus Texas, inaction and choices by the federal government about how to enforce or not enforce immigration laws. So in the United States versus Texas, Justice Kavanaugh for the court and then Justice Gorsuch in a concurrence for 3 justices sort of, I think the very implication of their opinions in finding no standing for Texas in that case, even though Justice Kavanaugh's opinion sort of tries to cabin how much the factual context of immigration enforcement might cut elsewhere, really is to say states are no longer special for standing purposes. States need to establish standing the same way pretty much as anyone else. And that actually is a big deal, I think, because it is certainly a change for Massachusetts versus EPA. In Brackeen, the ICWA case, which we also sort of talked about, the Indian Child Welfare Act case, states, you know, part of Justice Barrett's opinion was states do not have standing to challenge the whether that statute violates the Equal Protection Act. And the reasoning there was states can't say that their view that they would be forced by federal legislation to violate the Equal Protection Clause would be sufficient to confer standing on them. And then there's like yet another standing opinion, but this time for private plaintiffs in the student loan cases, where the court said unanimously, an opinion by Justice Alito, The private plaintiffs did not have standing to sue there. Their theory was they were excluded from the loan forgiveness program, and they wanted to then not only challenge their exclusion, but use that as a way of actually taking down the entire program. And I think the lesson from all those cases is if you are sort of a little outside of so I guess what you would say, like the traditional prerequisites for standing for private parties, the court is going to look at you not favorably. And it's sort of part of a larger trend where the court has tightened the criteria for standing over the last couple of terms. I mean, TransUnion, it was a really important case. The recent case tightening the criteria for article freestanding, and I think the court's just really interested in this area of law and very interested in kind of doing something.
Adam, on your Substack site, you penned a column this past April entitled, "Does Standing Follow the Merits?" So some of the cases that Sarah was mentioning came down since you wrote that. I wonder if what you had to say in that would apply as well to what or came down with subsequent to that.
Yeah, I mean, standing does usually follow the merits. There's some interesting exceptions, but usually I think the most dramatic example of that is in the student loans case, Biden versus Nebraska, where you had like these two completely unrelated issues. One is whether like Mohela, which is this entity that was created by the Missouri government, if it was injured, whether Missouri had standing based on the injuries to Mohela. And then you had this question about the proper interpretation of federal education law and whether the student loan forgiveness program was consistent with what the statute required. There was no correlation between those questions. You have no reason to expect your philosophy on one issue would be correlated with your philosophy on the other issue. Yet all 9 justices voted the same way on both. You had 6 justices saying that there was standing and that the challengers won. You had 3 justices saying that there wasn't standing and that the challengers lost. I don't know what to make of that, except, it's a little depressing, I guess, but, it's not the first case in which that kind of thing happens. Just another random example, there was a case a few years ago involving, mootness, involving the New York gun law. And just on this mootness question, the dissenters were Justices Thomas, Alito, and Gorsuch, were the exact justices you would think would be most persuaded on the merits of the challenge to the gun law, even though the mootness question had nothing to do with that. Similarly, United States versus Texas, this term, I mean, if you just look at the alignment of the justices, it's similar to alignments you get in cases having nothing to do with standing, where you had the 3 Democratic appointees joining Justice Kavanaugh and Chief Justice Roberts in the majority. That's the exact alignment you got in cases like Allen versus Milligan, which had nothing to do with standing. And so, and in fact, in that case, Texas was the challenger, and so it was sort of a conservative-leaning challenge, you might call it. So yeah, I kind of think that standing does follow the merits in a lot of these cases. And whether it's based on philosophy or motivated reasoning or what, I'll leave that to the law professors, but I think that hypothesis continues to be true.
Thanks. So Julia, the court decided 2 white-collar criminal decisions in May in your sort of practice area the same day, involving the honest services fraud statute and the wire fraud statute, respectively. So what impact do you think those decisions are going to have on federal prosecutions and white-collar defense?
So the 2 cases are Prococo and Connolly. In Prococo, the government prosecuted a former government official who was a lobbyist in the private sector at the relevant time. The government's theory was that a private citizen owes a duty of honest services to the public if he dominated and controlled any government business, and people working in the government actually relied on him because of a special relationship he had with the government. The court unanimously rejected that theory of honest services fraud as too vague and open-ended. Connolly was another 9-0 decision. That case involved a defendant who had been involved in a bid rigging scheme for state contracts. The government prosecuted him under what's called the right to control theory of federal fraud, that this scheme deprived the state of property, with property defined as potentially valuable economic information necessary to make discretionary economic decisions. The Supreme Court rejected the right to control theory of property and held once again that the federal fraud statutes extend only to traditional property interest. Now, what's notable about both cases is that the Solicitor General really declined to defend the prosecution's legal theory. Now, the Solicitor General didn't confess error, but made arguments that were more akin to harmless error to defend the judgment. That's striking. And I think what we see is more and more cases that the court has been receiving in recent years, where it's fairly clear that the government's theory is just too broad in the federal fraud context. I mean, you don't have to look any further than the Solicitor General not being willing to defend the core theory at issue in 2 cases before the court this term. So I think in terms of impact, Connolly is likely to have more significant consequences of the 2 decisions. I think we've seen in recent years that prosecutors have increasingly based fraud prosecutions on different types of right to intangible information theories of property. And I think that after Connolly, it's doubtful that those prosecutions are viable. I think Percoco is a little bit more of a one-off, but I do think Connolly will have fairly broad consequences for prosecutions, especially in the Second Circuit, where the right to control theory has been around for many years now.
Were there broad circuit splits in those 2 cases that were resolved? I mean, it's rare to have decisions come down so unanimously or near unanimously if there was a broad circuit split.
I wouldn't say broad, but circuit splits, yes.
Okay. So staying with you for a second, the Slack Technologies case, which WLF filed a brief in, what's the importance of that? And were you surprised that it came out unanimous?
Absolutely. So Slack came about as a result of a new way for companies to go public that the SEC approved just 5 years ago, a direct listing. So unlike in a traditional IPO, a direct listing can result in the sale of both registered and unregistered shares on the first day of trading. The question in Slack was whether to bring a claim under Section 11 of the Securities Act of 1933. A plaintiff must plead and prove that she purchased securities registered under the allegedly misleading registration statement. For decades, lower courts had held that Section 11 liability attaches only when a buyer can trace the shares she purchased to the allegedly misleading registration statement. The first of these opinions was a Second Circuit opinion by Judge Friendly. But in the context of a direct listing, the Ninth Circuit and Slack departed from that longstanding understanding of Section 11's tracing requirement, basically on policy grounds, that the tracing requirement made it difficult, if not impossible, to have standing to bring a Section 11 claim in the context of a direct listing. The court unanimously reversed. I think that's the decision most folks were expecting in Slack because of the fact that really when you look at the Ninth Circuit's decision, it's a policy decision and you have the longstanding precedent on the other side of the equation going all the way back to Judge Friendly. And when Judge Friendly is on your side, that's usually a good thing with respect to enforcing the tracing requirement. Now, I think Slack clearly makes it more difficult for plaintiffs to bring Section 11 claims for direct listings than for IPOs, but there are still areas for companies going public via direct listing to have quite a bit of worry in the space. The first is liability under Section 10B of the Securities Exchange Act of 1934. Still remains a possibility for registration statements issued as part of a direct listing. And oftentimes, although not always, in practice, Section 11 claims and Section 10B claims are brought in the same suit, challenging an allegedly misleading registration statement. I think one thing that might have been a little bit surprising about the court's decision in Slack is that the court declined to interpret Section 12 of the 1933 Act, cautioning that it contains, quote, distinct language that warrants careful consideration on remand. And I think here, picking up on some of the themes Sarah and Adam have commented on, you could get a sense a little bit of oral argument that there was a unanimous consensus on the Section 11 issue, but potentially not unanimity on the Section 12 issue.
So I think one of the cases, Sarah, that would fall under the rubric of those that fizzled out this term was Gonzalez, the Google versus Gonzalez case. It was argued the same day as the Twitter versus Tomney case. If Twitter came out a certain way, then Google probably would not be as quite of a big deal in terms of taking head on the issue of Section 230 of the Communications Decency Act. And that's really what happened. So can you talk a little bit about how that happened and whether you think the court's going to be in a position to have to deal with the breadth of Section 230 eventually.
Sure. And so full disclosure, I worked on the Google side of this case. And so take with a grain of salt, but I truly believe this is one of the biggest wins for business of the term, which might sound weird because the court didn't end up deciding anything. But the backdrop to this case, this pair of cases, was the petition, regarding the scope of Section 230 said there was no circuit split. The petition said the courts don't disagree at all. The courts and the petition also said sort of Section 230 does at least cover certain functions that websites are doing when they host third-party content. It had no amicus briefs, and the same question had been denied many, many times before. Yet the court granted the case, and on top of that, the court granted the case in a posture where it was truly, I think, one of the strangest grants, just objectively speaking, given the procedural posture in which there is a pair of cases. The Ninth Circuit in one case said that Section 230 of the Communications Decency Act precluded holding Twitter, Facebook/Meta, and YouTube/Google liable for third-party content. In that case, it was ISIS's use of those websites to sort of put up various messages. And in a separate opinion, the Ninth Circuit said, setting that aside, you have pled a theory of liability under the Anti-Terrorism Act. So it's sort of like a left hand and right hand, not necessarily talking to each other in opinions. And the court granted both of those. And so the conventional wisdom going into it was, why would the court grant a case that doesn't have a split if it did not want to interpret Section 230, especially given that Justice Thomas had written separately about his views of Section 230 and why he thought that lower courts were misinterpreting it. So after argument, I think it was clear two things were clear. One, that the justices were troubled, I think, by Justice Thomas's separate opinion and his sort of theory of Section 230, and not willing to sort of go there, and that there were perhaps more arguments on the table just from a textual approach to Section 230 than the lower courts had sort of fully explored. And then two, that as Justice Kagan said, the court is not the 9 greatest experts on the internet. And they seem to get pretty concerned during the course of briefing and argument that whatever they decided with respect to Section 230 could in fact break the internet, not something they seem to want to do this term. And so Tomna offered an off-ramp, which makes sense when you sort of think about the procedural posture, which was if there is no liability under the Anti-Terrorism Act for websites that are alleged to simply have provided an ability for lots of people, including some members of ISIS, to post content that does not qualify as aiding and abetting terrorism under the text of the anti-terrorism statute. You need a lot more than that. That was the out that the court chose. So will they want to return to Section 230 in the future? I don't know. I mean, the court, when it dodges or refuses to decide cases with this kind of buildup, at least historically, sometimes there's a cooling off period where the court sort of thinks, this seems like a good issue to take. Turns out it's super duper complicated. Maybe there's more, there's more nuance or more counter arguments than the court might have initially thought. And so it can take a little longer for that question to return. So I think if there's a circuit split that emerges on Section 230, then the court might hop in. But in the meantime, they seem to have moved on, at least for next term, onto other issues with respect to social media that we can talk about when we're doing a preview of next term. So for now, I don't know. It seems like their appetite to intervene in the internet has been satisfied.
So one of the issues I wanted to move on to is First Amendment. That could have played prominently in a trademark case this term, just as the First Amendment played prominently in trademark cases like the TAM case in past terms, but it didn't really end up that way. Adam, can you talk a little bit about how Justice Kagan didn't get into the constitutional issue much in the Jack Daniels versus VIP products case, and on what grounds did the court ultimately decide that case?
Sure. So the short answer is that the court didn't get into the constitutional issues because it didn't need to, because of its holding that was narrower than was requested by the litigant in that case. So just to give a bit of background, the case had to do with a dog toy and whiskey. In fact, the first sentence of the opinion is, this case is about dog toys and whiskey, 2 items seldom appearing in the same sentence. So most of us are familiar with Jack Daniel's whiskey. We all know what the bottle looks like. So it turns out that a business decided to make what it characterized as a parody of that, which was a dog toy that says the old number 2 on your Tennessee carpet on it and shaped like the bottle. So like, as some of the justices asked during oral argument, it's not clear why this is like funny. I mean, I would never buy this. Like, even if it was given to me, I wouldn't accept it as a gift. It just seems gross and stupid. But anyway, apparently this did well enough that it sold pretty well, and Jack Daniels sued for trademark infringement and dilution. So the case started to implicate a case from the Second Circuit called Rogers versus Grimaldi, which was like a huge case in the content world, like movies and movie studios and people like that really care about this case a lot. That was a very different case that did not involve whiskey and poop. It involved a movie. So we all know who Ginger Rogers and Fred Astaire are. And so a filmmaker made a movie about 2 dancers. It was called Ginger and Fred. It wasn't actually about them. It was about 2 dancers who danced like Ginger and Fred. But clearly the title had like artistic significance to the film. And so I believe Ginger Rogers, the Rogers and Rogers versus Grimaldi, sued, saying that it was an infringement. It was like a trademark infringement, as well as other claims. And basically the court said that there's a real First Amendment problem with applying a trademark in this situation when you're trying to silence something that's significant to an artistic work. And so the court basically, the Second Circuit in this case, Rogers, devised a 2-part test that says that if you're suing over, if you're bringing a trademark claim against something that's artistically significant, you lose unless you lose as long as there's some artistic relevance of the use of the mark to the work, unless it's like actively misleading. So if like you're like lying about the provenance of your product, then maybe you can face a trademark claim. But if you're not, and there's some relevance, artistic significance to the use of the mark, you're free from trademark liability, even if there's a likelihood of confusion, which is the typical test under trademark law. So like, as I said, movie studios and other content filmmakers, content owners and filmmakers and things like that love the Rogers case. So in this case, the Ninth Circuit rather weirdly, in my view, held that the Rogers exclusion applied to this trademark infringement suit against the dog toy, which is not a movie or a book. It's like an ordinary commercial item. And so a cert petition was filed asking the Supreme Court to repudiate Rogers. I was going to say overrule, but you can't overrule a lower court decision, but it kind of felt like overruled to all the content owners who had relied on it for such a long time. But of course, that raises First Amendment issues. If you're going to try to silence a filmmaker from using a particular title that's artistically significant, obviously there's some First Amendment issues. So even though the petitioner asked to overrule or repudiate Rogers, the Supreme Court didn't do it. It actually just said that Rogers did not apply in the much more narrow situation in which a person was actually using the mark the way marks are usually used, which is as a designation of source for someone's goods. So in like Ginger and Fred, the Ginger and Fred mark was not used to signify, yes, this is endorsed by or made by Ginger Rogers. It was used because that was what the movie was about. And so the court did not address that kind of situation and said that when you're using the mark as you're typically using it, which is a designation of source for the goods, then Rogers doesn't apply. The First Amendment implications of that type of case are less significant. So that's why the court avoided the First Amendment issues, because it said that in the particular context of this case, when the mark was used to designate the source, the First Amendment did not protect or did not offer protection above and beyond the typical likelihood of confusion test, which itself takes into account parity as a potential defense. The court didn't decide one way or another, how Rogers would apply in cases like Rogers itself, when it wasn't used as a source identifier.
Thank you. Another case where the First Amendment was squarely at issue and was the basis for the decision was the 303 creative decision, which came down the last day of the term. Now, most of the post-opinion commentary have focused on whether that decision allows businesses to refuse service to certain people, Sarah, but it would seem to me that the issue of the commercial nature of the speech that was at issue here has kind of been missed. Is there going to be any sort of movement in the commercial speech jurisprudence, the compelled commercial speech jurisprudence, especially after 303 creative, you think?
So I think this opinion is so interesting because it's kind of 2 ships passing in the night. And I read the majority opinion as really about compelled speech writ large. And so while a lot of the news coverage of the case sort of focuses on, I think, some of the points by the dissent viewing it more in the line of a social issues LGBT rights case. I actually like the framing of the majority, at least as I read it, really is very broad, maybe even in such a way that sidesteps some of the LGBT specific issues. And what I mean by that is, it is a paean to the idea that the government cannot compel speech. Really some very sweeping and categorical statements about to that effect, weaving together previous cases about compelled speech, including cases in the commercial context, and saying, if you are someone who is engaged in expressive speech, even if you are, doing it because you're a website designer, as in this case, or some other commercial context, and the government is trying to compel you to, take a different message that violates your conscience, no can do, like that violates the First Amendment. And so it's almost a shorter opinion than I think people expected, simply because it goes the path of compelled speech is bad, as opposed to a route that might have focused more on LGBT specific issues and sort of trying to weigh, that can Colorado have a public accommodations law that says you need to engage in particular speech, in that case, whether the wedding website designer needs to also design websites for like celebrating gay marriages in addition to other marriages in violation of her religious views. So the court didn't get into that as much in terms of the legal reasoning of the case, didn't get into sort of like a lot of questions you might have about narrow tailoring, other stuff. It was really just like a very broad, again, focus on speech, compelled speech in general. And that's why I expected it to be a case that, even though this was about a website designer, I could see a lot of people going forward who are facing compelled disclosures in other contexts, citing a lot of the language in this opinion that's weaving together a bunch of different compelled speech precedents. And again, the court's expressly rejecting the idea that it makes a difference that the wedding designer was in fact, doing this commercially. They say, nope, it's compelled speech. Same sort of thing as some of the other cases that were more purely expressive communications in a non-commercial context.
So it's kind of similar to one of the cases that the court did make reference to, the NIFLA case from a couple of terms ago, where that wasn't really a commercial case per se, but the way that people have read it post opinion is that it could broaden the whole concept of being able to fight back against compelled commercial speech. Is that accurate?
Yes, and so that's the reason why I expect this, why I expect 303 to create to appear in sort of a lot of context in which you might not, if you just read the headlines about the case, expect to see it in legal briefs going forward. Because again, if the court is serious, and it seems to be serious about saying that compelled speech in a wide range of contexts is extremely constitutionally suspect, this case is a pretty strong foundation for making that argument in other contexts too.
So we could probably do an entire program on what the heck the Ross case is and what it means. But since we only have a little bit of time left, I'll ask Julia to answer a question that was posed rhetorically on the Volokh conspiracy by Professor David Ross. He says, are future courts bound by the outcome in Ross or by its holdings? What did David Post mean about that? And what do you think is the answer to that question?
So Professor Post raises a fascinating feature of the court's decision in Ross, which scholars call a voting paradox. Adam touched on this a little bit in his opening remarks. If you add up each of the justices' views expressed in Ross, the plaintiffs in this dormant commerce clause lawsuit should have won. You have 6 justices that agree that the dormant commerce clause allows courts to balance in-state benefits against out-of-state harms to determine whether to uphold a regulation, even where these benefits and harms are hard to compare. And you have 5 justices who agree that if that kind of balancing is permitted, then the law at issue in Ross is plausibly unconstitutional. That's 5 votes, theoretically, for 2 propositions. Such balancing is permitted, and that under such balancing, the law is plausibly unconstitutional. So if that were the end of it, petitioners should have prevailed and been allowed to continue their case. But that obviously didn't happen. The court affirmed a dismissal of the complaint because 5 justices voted for the ultimate outcome on different non-overlapping theories. So what does a lower court do in a situation like this? There's something called the Marx rule, and that rule provides that if 5 justices don't agree with any rationale, then the narrowest grounds supporting the judgment prevail. as precedent. Now, many commentators have argued that the Marx rule doesn't really make sense in the context of Ross because there's no nearest ground. There's no resolution that's a logical subset of any other. So I think this is a difficult situation where you have different lineups of votes, and you have a rule that one usually looks to that may or may not be helpful, really, with respect to this particular decision. So I think it's going to be interesting to see what the lower courts will do going forward with this decision.
Adam or Sarah, if you have any thoughts on this, definitely would love to hear you chime in as appellate litigators.
Yeah, I'll speak and then, go ahead, I'm sorry. So I was going to say, I just don't think that there is a holding in Ross. I mean, you know, it's funny, this issue versus voting paradox, I've heard law professors talk about it for years. There's a case from like 1991 called Fulminante, where it was like the classic case like this, where you had like one person said it was harmless, but it wasn't an error. One person says it was an error, but it wasn't harmless. And you like accumulate those votes together, you get 5, but you had 4 on every proposition. And people have talked about this in theory since then. And suddenly now you have this case. It's absolutely classic issue versus voting paradox case. In my opinion, it's not really the job of lawyers or courts to try to like come up with like abstruse theories about how exactly to figure out the narrowest opinion, because there isn't one. I think if I'm a lower court, I'm going to say there's no opinion on the Pike issue that has garnered 5 votes. There's no intelligible rationale that can really be deemed the majority of the court, and then the law stays where it was until the court takes a new case or maybe the composition of the court changes. I just don't think that Marx works in this kind of situation.
Sarah?
I guess I'll just add, I think that lower courts are going to just read the tea leaves on this one. It's not so much even which opinion is controlling. It is, if you take a step back, this was an effort to breathe life into the Dormant Commerce Clause in a case in which California was trying to like dictate very like costly aspects of pork production for the nation. And the court affirmed, and that is sort of a surprising holding, because you might have thought the court took this case because they thought California was like being piggish, so to speak, in terms of regulating pork production. The fact that this challenge failed, and the fact that the court could not come to a conclusion that like anyone can discern, seems like a real deterrent to bringing Dormant Commerce Clause cases to the Supreme Court. They are not hungry for this type. I mean, I'm just going to keep going with the meat puns. They're not hungry for this type of meaty issue. So stay away, I think, is the message from the court. And for lower courts, I think that was already kind of the message they were doing. Dormant Commerce Clause challenges are not exactly known in sort of appellate courts as like clear winners. And I think that is just going to get reinforced by the fact that this was such an unbelievably fractured opinion.
So you don't think there's much of a chance that if the Mallory case, for instance, goes back to the Pennsylvania courts and the Norfolk Southern raises Dormant Commerce Clause arguments, that the Supreme Court's not going to want to jump back into that case because they already heard it once and it has Dormant Commerce Clause issue and they don't really want to deal with that again?
Yeah, I mean, I would hazard like an adage from this term, which is like, don't bring Dormant Commerce Clause or personal jurisdiction cases to the Supreme Court is on par with like, don't start a land war in Asia. Like, don't do it.
Do you think that preemption is going to become a more prominent argument in some of these cases where there's state regulation than there had been before because of this resistance to get into the Dormant Commerce Clause?
I think it will, just in the sense that it feels like, I mean, the cases have the feel of, it feels like there is something, wrong or unusual to a lot of people with what states are doing. I mean, that was sort of the vibe of, that was a little bit of the vibe of Mallory. It's like, if it's so easy to just sort of like exert jurisdiction over every company by saying like, you must sign up for general jurisdiction over yourself to operate in the state. How can you do that? And I think that's the gist of Justice Alito's concurrence too. It's sort of like, there seems like there's something wrong with it. It's not the due process clause because there's a 1917 case that just rejects that and the court's sticking with that, but there should be something else wrong with it. And maybe it shifts into preemption type arguments, maybe not. I mean, preemption itself has not exactly found a super friendly home in the court, certainly not implied preemption. So I think people will look for creative arguments, and that's called lawyering. And yeah, people keep trying.
also going to probably lend itself to a good amount of lobbying as well, because states obviously can or can't pass these kinds of laws, or they can certainly repeal them if they have them on their books, and nothing in the case said that courts had to have these kinds of laws on their books. So it should be interesting to watch there as well. As we're coming close to our end of the hour here, I wanted to go around and give each of you a chance to talk about what you're paying attention to for the next term, and both on the merit side, already granted, and on the petition side. So Adam, you want to start off, and then we'll go to Julia and then Sarah?
Sure. So I guess one case I'm watching, because I actually represent the petitioner in that case, is called Atchison Hotels LLC versus Lawfer, so I'm a little bit biased on that. It's a case about standing. It's about whether testers have standing to sue under the American with Disabilities Act. So just to say one more word about that, Ms. Laufer, the respondent in the case, sues lots of hotels, including our client, alleging that they don't post information about hotel accessibility on their websites, but she actually doesn't intend to go to the hotel. She claims the injury is just that she has a right to get the information from the website, irrespective of whether she's going to use it. Our position is that no, you're not injured unless you're going to use the information. And if you're not going to the hotel, you have no reason to care whether the hotel is accessible. And that's the dispute that the parties are going to be litigating. In terms of pending petitions, one interesting case is called Community Housing Improvement Program versus City of New York, or CHIP versus City of New York, which has to do with whether the court will re-enter the fray of rent control laws and whether they result in takings liability. Basically, rent control laws have gotten more and more stringent over the years. New York enacted a really stringent one called the Rent Stabilization Law. The court hasn't gone here for years, but petitioners basically say that it's so stringent, it's like a per se physical taking, or possibly that, because landlords have to basically subsidize tenants who have financial problems, that's essentially some kind of regulatory taking. And the court hasn't entered this area in quite some time, but if the court actually grants certiorari, that could have very significant effects on the constitutionality of rent control legislation in numerous cities all across the country.
Thank you, Adam. Julia?
So Jarkessi is at the top of my watch list, but I'll add two other administrative law blockbusters, or potential blockbusters. The first is Loper Bright Industries Enterprises, which Adam mentioned in his opening remarks. I think what's interesting there is the petitioners presented two questions in their cert petition. The first was about the agency's interpretation of the statute, and the second was whether the court should overrule or significantly narrow Chevron deference. The court granted only the second question presented, suggesting it may make the leap of either overruling or significantly cabining Chevron deference. Now, that would obviously be a highly significant development, but especially in the lower courts. The Supreme Court itself has not actually relied on Chevron to uphold an agency interpretation of a statute since 2016, so 7 years. No justice even mentioned Chevron this term, except Justice Gorsuch in an opinion urging the court to grant a case to overrule Chevron. So deference with respect to this within the Supreme Court, does not feel as important as it used to. But deference to agency interpretations under Chevron is standard in the lower courts, and the court is taking fewer and fewer cases each year. So the Court of Appeals is often the last stop, even for significant agency interpretations. So I took a quick look before this panel, and by my count, the courts of appeals have cited Chevron 95 times in reported opinions over the last year. So that could be a potential sea change in the law. The other case for me is CFPB versus Community Financial Services Association. In that case, the Fifth Circuit held that the CFPB's funding mechanism violates the appropriations clause. So another structural constitutional challenge, but this one I think is one like we haven't seen before, unlike at least some aspects of Jarkessi. Now, if the court were to agree with the Fifth Circuit there, it would have to decide the question of remedy, which would be potentially interesting as well. So if the Fifth Circuit were correct, would you have to vacate the underlying agency rule as a result of the funding arrangement? So I think that too would be an interesting wrinkle in that case if the court gets there.
Thank you. Sarah?
So I'm interested just in a big picture sense of what is the court going to grant next? Because the feel right now is a very different term than I think when we were all doing like term looking ahead like last year. In terms of potential blockbusters, like we all care about administrative law cases. They're super interesting. They may be very consequential, but they don't have this sort of same range of likely, of cases that might sort of be hot button social issues. I mean, there is a Second Amendment case that just got granted called Rahimi. And I think the question there, it involves Second Amendment rights for someone with a history of domestic violence. And I think the question there is how will the court articulate how to do the analysis that it prescribed in Bruin? So there's kind of a different feel to the significance of Rahimi. It's sort of like what limiting principles are there on Bruin? How do you do the historical analysis? Not like what does the Second Amendment involve, like writ large. So I wonder if this is going to be more of a, lawyer's lawyer term of really important administrative law cases, and quite a lot of them, where the rest of the docket is, significant, but kind of a little more bread and butter.
So you think that what Chief Justice Roberts said at the end of his opinion, his last opinion of the term about taking the volume down, may sort of carry over to the next term?
Maybe. I mean, honestly, like if we're up to me, like Humphrey's executive is like where all the excitement is, but I know that's not sort of where the public opinion lies. So
That's true. Well, thank everyone for joining us today. And thank you for each of you for your time and your thoughts. Really appreciate it. And hope everybody has a good rest of the summer, however short it's going to be. Take care.